Anthony Carls again, and I'm here today with attorney Robert Keenan from our Menominee Falls and Milwaukee branch. And I want to thank you first of all for being here today. I know you're busy. So the topic that we wanted to talk about today is what happens in a divorce when one person wants to try to associate a value to a college degree, and they're getting to the point where they need to divide assets. Is there a value imputed to that degree or not? That's a question that comes up time to time online and on our forums.
That's a great question, Tony. The short answer is no. So there isn't a value that you put on a professional degree, okay? It's not like a house or a car or a retirement account where you can quantify. The courts have wrestled with this issue on a couple of different occasions, and they've essentially come to the conclusion that a degree, though it costs money to obtain, is too intangible of an item essentially to value for the purposes of dividing the marital estate. They are considering the degree for other aspects of the divorce, but for the purposes of actually putting a value in dividing how much of the marital estate each party will get, they do not put a value on degree.
So specifically, if my wife and I were in the position where we needed to get a divorce, and I spent $60,000 to get my degree, and we have a house that's worth $100,000, that's $60,000 to go get the degree that we spent, would there be no value assigned to that?
Correct. So when looking at the marital estate, they will take in the value of your home, they will take in the value of your retirement accounts, any other assets you guys have, they'll put a value on those, and then they will divide it based off of a number of different factors for your particular case. The length of the marriage, the contributions by the parties to the marriage, whether the assets were premarital or acquired during the marriage, a lot of other factors they put into. But with respect to a professional degree, they're not going to assign an actual value to it. However, that does not mean that the court is not going to consider what the parties had to do in order to obtain that degree. For example, if you obtained your PhD, okay, and it took you 4 years and you spent $80,000 to obtain it, and during those 4 years you did not work, and your wife was the primary earner for the family, so she was paying the mortgage, she was paying the utilities, etc., while you were obtaining this degree. That circumstance there is something that the court will consider for the purposes of dividing the assets. Okay, in Wisconsin, there is a presumption that the parties will divide the marital estate 50-50, okay, in a sense. However, there are ways you can move off of that. And for example, one of those would be if for 4 years during the marriage of, let's say, a 10-year marriage, one party was not contributing financially to the marriage because that person was obtaining a degree, whereas the other party was the primary earner, primary provider for the family. So they will take that fact into consideration, and possibly the division of the estate may not come out to be an even 50-50. It might be more favored towards the primary earner during the marriage to account for that time that person contributed to the marriage while the other person was obtaining a degree.
Interesting. So how might that then be applied to maintenance? Because that person that, if it was myself, I went and was getting a PhD, and my wife was paying for me to do that, and I wasn't working. But now we're getting a divorce after that fact, and now I can earn $300,000 a year, and she's still only going to be able to make $50,000. How would that get handled in that scenario?
That's a great question, and it's something we also see a lot of, because unfortunately, divorces are never timely, and a lot of times when they occur is after somebody would obtain a degree or gets a job promotion, and there's a big change in the financial circumstances of the parties. So, kind of like what I said with respect to dividing a property and how the courts will consider the contributions by each party and what happened during the time of the degree for dividing the marital estate. Those are also factors that will be considered for the purposes of calculating maintenance, or previously known as alimony. Maintenance is a rather subjective and discretionary element of a divorce. There are a lot of factors that go into whether or not a maintenance order will be divided or be awarded. And the statute states that the different factors, among others, length of marriage, earning potential of the parties, quality of life the parties had while they were married, And then specifically, contributions by one spouse to the education or increased earning powers of that spouse. Meaning, if one person was paying for the other person to get a degree, okay, and as a result of that degree, or as a result of that investment, as you will, the earning party ended up getting more money. Those are factors to be considered for an order for maintenance. Okay, so essentially, what you would want to take away from that is if you were obtaining your PhD, and let's say at the time before you got your PhD, you were making $40,000 a year. You obtained your PhD, your earning potential went up twice, so now you're making $80,000 a year. Okay, and during the marriage, or during the time you obtained your PhD, your wife was making $50,000 a year. Okay, and she contributed to the marriage. The courts will look at the factors of, okay, now you've obtained this degree, this is your earning potential, this is what she's making. They might want to equalize the income and to see kind of what a maintenance order would look like. Again, but that's one factor to be considered for the purposes of maintenance. There is no guarantee that a maintenance order would be issued just because one party contributed to the education of another. The main factor is length of marriage and quality of life that the parties had during the marriage, if that makes sense.
Yeah. So then in this case it could be considered, but it might not be the smoking gun to get what somebody would want in that scenario.
Exactly. I would say for our viewers here that the main consideration for whether or not a maintenance order will be awarded in a divorce is the length of the marriage and the quality of life the parties enjoyed during that marriage. Because what the courts want to make sure of is that when parties separate, they have a similar standard of living they had during the marriage. Okay? And that standard will extend based off of how long the parties were married, okay, and the earning potentials of the parties. So, for example, if you have a 30-year marriage and one person was the primary earner and the other person stayed home, okay, and the parties divorced, then they're going to want to look at what they need to do so that the person who stayed home would have a similar quality of life they had during the marriage. And one of those factors that they look to is what were the contributions made, what were the sacrifices, as you will, made by one party in order for the other party to obtain a degree.
Awesome. Well, Robert, I thank you very much for being here. We appreciate your knowledge and insight into this issue.
Case Law Friday is a Sterling series focused on communicating in layman's terms, cases of precedent, statutes that guide decisions, and court procedures important to getting results in family law. Please like and subscribe. We hope these deep dive conversations create clarity, enabling you to better understand the rules that govern how decisions get made in family court.